My name's Laura. I'm one of the solicitors at Ridout's Professional Services. Now, you'll see on your chairs I've left you a party bag. Some of you may have had these before, but I'm conscious we're a bit short of time. It's got information in it about what we do as a firm. High level, and for your interest today, all we do is represent providers. So everything that I speak about comes from that perspective of dealing on a day-to-day basis with providers. I'm going to say something a bit controversially, but in the nicest possible way. I hope that after today I never see you again. And that means that you're not in any trouble and you don't need me, because we tend to be a bit of a distress purchase for clients at times. But the reason I'm here today in relation to good and outstanding care is a lot of what we do in relation to challenging ratings applies not only to the services that are in difficulty, but also those that are good and want to get to outstanding. So that's why I'm here today. In addition to doing sort of ratings challenges, which I guess are my bread and butter work, we also do things like helping with registrations. I've done quite a big case recently in relation to registration of learning disability services, which you may or may not have read about, but that's something that I'm quite interested in. But for today's purposes, I'm also conscious that we're a bit behind schedule, so I am going to try and speed through this perhaps a bit more quickly than I would have otherwise. Do stop me if you want to, if you have any questions. I will be hanging around for a little while at lunchtime, but then I do need to get back to London because I've actually got a challenge to ratings which is due with the CQC tomorrow, so I need to go back and get that sorted. So, without further ado, I shall get started. The headlines which I was asked to cover today are the overview of the law, legal framework and changes to the methodology of inspecting care in nursing homes, and also options if you do not agree with CQC's ratings. Now that could take a session in itself for the whole day, so I'll give you some highlights, some insights, some tips I've picked up from the ground. I don't mean to come across as someone who's very negative about CQC, but I want to just give you a flavour of everything that I'm dealing with. Nobody comes to me really because they've got an inspection report they're happy with. People come to me because they've had an outcome that they're not happy with, and that's sort of the background. So I've had feedback in the past that I'm quite CQC negative, and I don't mean to come across that way. I mean, after all, they keep me in a job. So, so the legal framework, I mean, I hope that a good and outstanding care workshop, if I need to tell you about what this is, then you probably shouldn't be here. But we do have the Health and Social Care Act, which is it is the fundamental principles, and it contains the overarching powers, duties and functions. Because I think it's quite easy, particularly for staff, to get bogged down in inspections being a matter of operations. But what we do have to remember, and we do for the purposes of challenges, is that as a public body, what CQC doing, they're a creature of statute and they have got laws and regulations that they must abide by, as you must with the regulations. I mean, the key points that will come out of the Health and Social Care Act is that it's all about public protection. It's a risk-based system, and they want to assure the public through publication of inspection reports. Recent pieces of information that come out of the CQC, their business plan, etc., will say that they want to focus on improvement, on risk, and on service users. I think for your purposes, particularly as registered managers thinking about inspections, what you need to be up to speed on are the regulations and obviously the fundamental standards. Now, a big problem with the fundamental standards, when we moved away from the national minimum standards to the fundamental standards that we now have, they're quite general. I think you might agree, and they're quite subjective. And I think sometimes when there are issues with inspection reports, the difficulty is that an inspector has said, you know, you use a lot of agency staff, or people have complained that you're short-staffed, so you're in breach of Regulation 18. It doesn't always follow, but the regulations are not very prescriptive. And so that's one ground for opening up to challenge. But anyway, in terms of the legal framework, we've got the regulations, which are the teeth. Now, the main ones are the fundamental standards, but there's the other ones that place obligations on you as well. For example, the registration regulations, and they are the ones that cover the issues like the notifications that you're required by law as a manager to make to CQC. Guidance is my next favourite. Guidance is something that you must be very, very familiar with as operations staff at the care home, as at provider level, when you're thinking about your inspection and your rating. The guidance is basically what CQC issue to tell you how to comply with the fundamental standards, and it gives us a bit of an insight into that subjectivity and what they're looking for them to be able to say you meet the regulations, and also what you need to do to be rated as outstanding or good. Now, that guidance isn't always, well, it's a difficult legal position. It's not binding per se, but some of it, for example, registering the right support, is statutory guidance, so you have to have a higher level of regard to that than you might otherwise. But what we see time and time again at the firm is CQC mixing up compliance with guidance and compliance with the fundamental standards, which is essentially the law. They are not the same thing, and we have to be very careful to separate that out. I'm going to dwell on guidance because in terms of CQC's methodology, this is where we find most of it. Now, we've already spoken about the CLOEs mapped to the regulations, and I would commend them to you. The other thing that I would recommend every provider is familiar with is what used to be known as the provider handbooks. I don't know if they're still called that. I don't know what CQC are doing with this. In November last year, they were replaced with this new simplified guidance, well, they said it was simplified. I'm not sure it necessarily is, but how CQC monitors, inspects and regulates adult social care services. And that is available online at that link that I've given you. It was updated again in May 2018. Now, these documents were published, they were supposed to replace the previous provider handbook and inspector handbooks because these were separate documents. And at the time they came out, I made a Freedom of Information request asking for the up-to-date version of the inspector's handbook. And they told me at that time that they didn't have an up-to-date version of it and that they planned to put it all online to make it transparent for providers and service users alike. However, it never got published online, the inspector's handbook. And I was delivering a presentation similar to this one just a few weeks ago. And as a result, I chased CQC up with an FOI request. And they have sent me various pieces of up-to-date documentation, which are basically guides for inspection teams. But they're really, really useful. If you want to email me, I don't have copies of them, but I can email them to you. They contain lots of different information about what inspectors will be looking when they come to your service. One key thing I think that you'll be interested in is there's a particular section in one of them which reinforces, this is not a new concept, but it reinforces the concept that CQC should be looking for good when they come in to inspect your service. And it gives you a whole list of prompts that inspectors are supposed to lead with to allow you to demonstrate how you're doing things well. And I'd be interested to hear what your sort of experiences with inspectors are. Certainly ones that I've had, it hasn't really been the case that it looks like they're inspecting for good. But again, from a lawyer's perspective, CQC are a public body, inspectors are civil servants. They have a duty to act in accordance with the way the guidance is published. And if this is something they're not doing correctly, it does set it up for a challenge. And I'm going to come on to the various different mechanisms for challenge later, but basically any element of CQC not behaving in a way that they say they're going to behave in their guidance is something that you can use as a hook to put challenges on further down the line. So that's important documentation. The provider handbook, certainly, because that is how you show CQC that you are meeting the characteristics. The ratings characteristics are published. You should be able to demonstrate that what you're doing reflects those characteristics. Again, they're very subjective. But I think that's an opportunity for providers because you can interpret them in line with what you're doing at the service. I do know from experience that for outstanding services, CQC are really interested in innovation. If you can use that buzzword, there's some things that I've seen described as innovative in care homes. I wouldn't necessarily say is particularly innovative, but that's the way they've marketed it to the inspectors, and that's what works. So that's just little perils as I go along. One thing that I think is worth flagging up, but maybe not in a good to outstanding workshop, but I'll raise it anyway, just in case you find yourself in this situation, is that one of the key updates in May 2018 was an update to the way that CQC are going to treat service that are repeatedly rated as requires improvement. Now, CQC's position on this is that good care is the minimum that people receiving services should expect to receive. And from, I think it's November last year, because they're backdating this guidance, for services rated as requires improvement on one or more occasion, they're going to start to take what they describe as proportionate action to help them improve. But what their guidance does allow them to do is, if you're rated as requires improvement more than once, they can consider that as a breach of Regulation 17. Now, if you're very familiar, as I am, with CQC's ratings matrix and the way that they aggregate ratings and whatnot, if you look at that, you will see that if you have a regulatory breach in more than one domain, in fact, in any domain, beg your pardon, you can't be better than requires improvement overall. So this is quite a dangerous use of CQC's guidance, and it's what I'm sort of alluding to in the last slide, is that...
Can you say that again?
Certainly.
In whole sentence.
In whole sentences, yes. So CQC, if you're rated as requires improvement on more than one occasion, CQC can, they don't have to, it's guidance, they can consider making you in breach of Regulation 17. Overall, looking at the way that CQC allocate the rating for your service, it states in another piece of their guidance, if you have any regulatory breaches, that acts effectively as a ratings limiter overall, and you can't be better than requires improvement. So I think it's something to bear in mind. It's an issue of CQC using guidance and mixing it up with their powers in law. Now, I have had some successful challenges where we've gone back to CQC and said, on one hand, we don't accept this as a breach, but if you do maintain that this is a breach, then you have got a discretion not to rate requires improvement overall. Now, I won't dwell on this because we are focusing on good and outstanding, but it's just to reiterate the point that there are anomalies with sort of the guidance, the breaches, and the regulation. And I'm not sure whether that is really the type of encouragement that sort of fosters improvement from the regulator's perspective. For me, it seems to be doing the opposite and actually making things a bit more difficult. But I won't dwell on that. It's just to give you a point on guidance. Another document which I have, which is useful for preparing for inspections, is the report writing guidance, which I can email to you if you're interested in that. Again, it's just really helpful because it gives you an idea of what inspectors should be looking for and what they should be saying and how they should be framing things in reports. They have a real tendency to put things in quite general terms, like some people told us meals were late, and when you drill down to the reality of what was said, it was one person, not, And so just little things like that, it's useful and it gives you an insight and it helps you to prepare your staff. But again, broadly speaking, the guidance forms part of the methodology for inspections. Sorry, I'm conscious I'm racing through this, and with my accent it sometimes makes things a bit tricky, so please do feel free to stop me at any point. Yes, we should all be familiar with the overarching elements of CQC regulation. They do your registration, your inspection, your compliance, and your enforcement. Now, I've already given out my party bag, so I've got no prizes, but what was the element that was introduced in October 2014? It's not a trick question. It's ratings. Before 2014, we didn't have what you would call excellence rather than compliance inspections, and I'll come on to that separately. But ratings come in, have brought a whole host of issues, because you can find yourself in the situation where you're completely complying with all the regulations, you've got no breaches, but CQC have applied the guidance, they applied the characteristics, and they're saying you're just good when you think you should be outstanding, or just requires improvement when you think you should be good. And I think there's a real tendency for the regulator to forget how irrationally stigmatising certain ratings can be, because let's be honest, people that are using your services, commissioners, family members, service users, they're really looking at the colours and the stars on the inspection report. They're not sort of looking at the subjective detail, and you really want to, you want to be able to put the best foot forward. But that's why ratings, and on the one hand, they have very many benefits, but on the other hand, they can be a bit tricky for providers. And it's this sort of, I guess it's a sort of two-part inspection regime under the Act, so the Health and Social Care Act. Compliance inspection, that's your compliance with fundamental standards, the regulations. Are you meeting them? And there isn't any minimum frequency of compliance inspections. It used to be 2 a year, but now, I'll come on to the slide that sets out the inspection timeframes. Now, the excellence inspections, and these are phrases that I would use, these relate to CQC's function in rating you. There are performance assessments under the Act, and these are the ones where CQC is obliged to publish how often they'll come back. So, you know, if you're good, they'll be back in 12 to 18 months. If you requires improvement, they'll be back in 12, inadequate 6 months. And so that's another part of the sort of overarching legal framework. And these, I don't know, I think you probably will be familiar with these timeframes. Points to note, though, is just in terms of, and I'll come on to it later to talk about, you know, say you're good, you think you could have been outstanding, you're trying to decide whether or not you've got the time or the capacity to do a challenge to the report. I would say that if you've got the evidence to do it, you should do it, because in this sort of context, you're rated as good. It's going to be 24 months before you see CQC again. And as we've heard in the talks this morning, it's so easy to go up and down. If you think you're outstanding and you've got the evidence to prove that, that's the narrative that you want to get out there at this time. And just a little point to note that when they changed these timeframes in their business plan in 2016, 2017, they switched it from the date of publication of the inspection report rather than the date of the inspection. Sounds like a small detail, but many of you will know the delays that there can be in an inspection report coming out. So that then adds on to your 24 months if you're waiting for an inspection. Another couple of legal points that I'm just going to quickly whiz through. I mean, these slides are fairly self-explanatory, but things that you should be aware of, particularly as registered managers and advising your staff, is that CQC do have really detailed powers of entry and inspection, and they're set out in the Health and Social Care Act. Sometimes it feels like they've got powers that are even more broad than the police and other regulatory agencies. It's very difficult to refuse entry to CQC. They can basically do whatever they consider in their mind is necessary or expedient for its regulatory functions. Now that, I mean, that's lovely lawyer speak, because that can be interpreted to mean pretty much anything you like. Key power that we often get asked about is, do CQC have the power to interview people? The answer to that is yes, particularly as you as registered managers. I mean, there should be no reason why you wouldn't want to. You want to be collaborative, you want to work with CQC, but we have had queries in the past where people have not wanted to speak to CQC. That's not going to reflect well on you, and they do have the power to ask you or your staff to do that. If there are any reasons that you think there might be concern, you can ask for someone to take notes or someone to accompany someone that's being interviewed. That's not unreasonable. Something that we've seen, I don't know if anyone here will have experienced this, is a Section 64 or 65 notice. Again, these are legal documents, and you mentioned turning up at a service and finding notices tucked in a drawer and things being ignored. If you see something that's labelled like this, this requires action. Not necessarily a red flag at this stage, but if you don't comply with it, it could turn into a red flag. It's basically where CQC are looking to get more documents and more information. 9 times out of 10, they're fairly straightforward, but if there's any issue with them, then you should clarify that with the inspection team. If you think you need more time to comply with it, then speak to CQC about that, but do not tuck it away in the drawer, or it can turn into trouble. And again, what they can ask for is the same test as when they're coming in to do their inspection functions: what is necessary or necessary and expedient to fulfil their regulatory functions. Usually it's care records they're asking for. Sometimes I've had requests for CCTV. Sometimes it's just explanations of further documents. There actually shouldn't be any real reason for them to have to do it under the Act. You know, as good providers, being collaborative, you know, we should have a working relationship with them, but it's just to flag up if you receive these or if anyone asks you about them, that's what they are. More serious, and I hope that this is not going to apply to anyone in here, so I'm not going to dwell on it, but Code B notices. And this is if CQC thinks you're committing an offence under the fundamental standards. Now, I think we're going to talk about, or it'll be covered later today, the obligations on a registered manager, but it's an important position and there's a lot of responsibility. You're essentially the person there that's required to ensure that the standards are being met, and you're on the hook, as it were, the same way as the provider is. And I say this not to alarm you, because I know that you're all doing a great job and you understand that. But if anyone were to find themselves in a situation where they're being served what's called a Code B notice, that gives an indication that CQC are thinking about investigating an offence under the fundamental standards. There was a little while where these were very common and we dealt with them a lot of times at the firm. I haven't seen them for a while, so don't be alarmed. I'm not coming here, look, all these frightened eyes staring back at me. But I've been asked to give you an overview of the legal powers, so I'm just making you aware of this so that it's not brand new information. So top tips when they're in the service. Particular attention to compliance with the Mental Capacity Act. Now, it doesn't fall under the Health and Social Care Act in terms of CQC's framework, but they are required to report on it. I can't tell you how many inspection reports I've seen since I started at the firm, but it is a lot. And I would say 98% of the time when there's difficulties in an inspection report, it relates to the Mental Capacity Act and people not understanding. But that's not only on the provider and the manager side, and I want to pick up on what was said in the talk this morning. Registered manager, you're the person in charge. You've had the training. You know what's going on. I have seen it published in inspection reports that the CQC inspector has got the MCA test wrong, and the registered manager has, even though they know the position, has become flustered and thought, the CQC inspector is telling me this, so that must be the correct way, so we must now put this new process into place. Just be confident. The CQC don't always get it right. Equally, providers don't always get it right, and just from looking at a lot of reports, I would give you that as a headline, Mental Capacity Act, so make sure that all your staff are up to speed on that and all your documents are as they should be. What feeds into this is brief your staff on what to expect from what the CQC will ask. Sometimes, and we've spoken about this as well, care staff come from a variety of different cultures and backgrounds. They perhaps are not asked questions in a format that they necessarily recognise as being mental capacity or safeguarding. And so the better we can empower staff to be proud, and these little prompt cards look great, you know, to really explain what they're doing in their own terms. Because you can also guarantee that the inspector will come in and speak to that member of staff that you don't particularly want. Or if there's one staff member that you think, oh, I really hope the inspector doesn't talk to them, you guarantee that's who that they're going to pick up on. So make sure they're well trained. And again, principal areas are MCA. This relates to a problem we saw for a while of many services not having a registered manager, which is a ratings limiter. So it's another one of these factors that CQC put in their guidance that mean you can't be really rated above a certain rating in certain domains. I've spoken about this already, so I'm going to just quickly rush through this. If you get a Code B notice, get advice. Make notes at the feedback session. If you think CQC have given you something that you're not happy with or you don't agree with, supply them with evidence and use it as an opportunity to showcase what you do well. It's your opportunity to show off to CQC essentially about how you're good. I've seen very recently, like in the last maybe couple of weeks, that CQC are now putting this line at the end of feedback saying this has been discussed. The provider was happy with the conduct of the inspection and all questions were dealt with. And I think that's to try and shut down queries after the inspection about things not being covered off at feedback. So don't wait until you do any kind of challenge or an email to the inspector. If you're not happy with something at the feedback session, that's your opportunity to discuss it and get it noted. If CQC have asked for further evidence, then you should provide that to them. This is more inspection conduct tips, I'm not going to deal with that now because what I think people are interested in and what I've been asked to cover off in a bit more detail is challenging ratings. Now I am going to try and get through it in the next 20 minutes because I am aware that I am all that stands between you and your lunch. But I'm always happy to take questions on this either in person or by email, so don't hesitate. I've spoken a little bit this morning about timeframes as one reason why you might want to challenge your inspection report. Another reason, obviously, is if there's factual inaccuracies. I mean, that goes without saying. Ratings, it used to be, when I first started at the firm, it was still a sort of widely held belief that you couldn't challenge your rating through the factual accuracy process. That's now well been dispelled, that myth. It's very clear, and in fact, CQC will say, if you try to do a ratings review, that you should have dealt with any issues about judgments at the factual accuracy stage, and they won't let you do it at ratings review. So that is your chance to do it. Your reputation. You want to be an outstanding service. Some commissioners and purchasers have certain expectations about what the rating ought to be. Some will not commission if it requires improvement. And your inspection narrative with CQC, I guess this ties into the sort of the time frames. If you are not going to be re-inspected for 24 months, perhaps it's a new inspection team that's coming round, they're going to look at your last report. If you've not challenged it, they're going to think, well, obviously that's the correct position at the home because that's what's on record with CQC. So sometimes, even if it doesn't yield a change in ratings, it's important to build up an accurate picture of your service. I've already mentioned about the new approach to requires improvement. I think if there is any suggestion that you have a regulatory breach that you're not happy with, then you must challenge that because you can then find yourself in a pickle for further inspections. And what I would say is I am seeing regulatory breaches used much more lightly these days and kind of inconsistently. And it has actually yielded some really good results to go back and to say to CQC, because again, sometimes CQC get bogged down in the guidance that surrounds the regulations. But if I've had the best success in going back and saying to CQC, you have said X is a breach of regulation Y. If you actually look at the terms of the regulation itself, this does not meet that threshold. And sometimes just putting it in terms like that is really helpful and has been successful recently. 4 main ways, and I'm not really going to get bogged down in the last one. There are some slides on the legal position, but I don't think this is really for today's audience. I'm going to concentrate on factual accuracies, rating review, and independent review. But the headline one is your factual accuracy. That is the main route to get your report amended if there's factual inaccuracies and to have your ratings improved. Now, as I say, for a lot of people, we're a distress purchase where they're inadequate, requires improvement, want up to either requires improvement or good. Equally, I've had 3 or 4 clients who've come to me for assistance with getting good to outstanding, and it's a similar, in a lot of respects, it's easier. But it's a similar approach, and that's why I'm going to cover it off today. The main thing I would say is that you should respond in detail and supply evidence, but you need to be credible about it as well. You need to take a step back. There's always that moment where you get the inspection report, and if you're not outstanding and you thought you were going to be, or if you're not good in a domain and you really thought you were going to be, there is that sense of real unfairness about it and wanting to sort of go back and say, I always like to take my instructions on these when I take the second phone call from the provider, because the first one, it's always, this is so unfair, and this is that, and this is the next thing, and that's that. And I'm like, right, okay. But when we drill down into the detail, I'm like, but is this factually accurate? And it's like, oh, well, yeah, that did happen, but I'm just like, right, let's have a think about it. Let me have a look at it. You have a look at it. We'll have a call in a few days. And by that time, everyone's calmed down, and we've had to think about what is actually credible, because CQC are getting more and more het up about the time that providers are, they say, wasting with factual accuracy challenges. Now, I fundamentally disagree with that. I was at a conference last week where Ian Trenholm spoke, and one of the delegates asked him, what are you going to do to get inspection reports put out more quickly? Now, I put the KPI up early. They've got 50 working days to get an inspection report out. Providers get 10 days to do a factual accuracy challenge. And he basically said, oh, well, we're going to reduce the time that providers have to do a factual accuracy challenge. Now, that was at Care England, actually, and it went down, I'd say, like a lead balloon in the audience. But there's a real sort of disconnect with the amount of time that you have. Use it wisely. Any mistakes, anything that you don't think is accurate, you should challenge. Regulatory breaches, does the evidence support it? What will be important in a good to outstanding challenge is, has CQC taken a measured and proportionate approach to rating your service? And what I would ask you to do in those circumstances is also to look at the ratings characteristics. They're your W1, W2, all of those, because they're the blueprint. You basically want to mirror to them. Your documentation says outstanding is this, we do this, and that matches that. That's the sort of formula for it. You can try and ask for the inspection notes. These have been really useful to me in the past for challenges. All I would say to you about that is that CQC have amended their guidance. They used to produce inspection notes relatively freely, as they should. Now they have changed their policy. There's a real reluctance to disclose them. They'll ask you to make a very targeted request about what you need. So for example, if they've referred to a specific incident or a specific service user or a specific area of the home and you don't know what they're talking about, you're within your rights to go back and ask for clarification on that. They may not supply the notes, but what I did have recently is a senior manager went through the inspection notes, and having done that, they said, in actual fact, we don't think this report is reflective of what was seen, and they actually scrapped the whole report and re-inspected. Now that's an unusual, it would be nice if it happened all the time, but it's just if there's anything you're unsure about, you do have that power as a provider. An argument that I have on an ongoing basis with CQC is sometimes they'll produce these inspection notes and they'll redact your service users' names and they'll say that that's confidential personal information. Now, that would be confidential personal information if it was being disclosed into the public domain, but it's coming back to you confidentially as the provider who holds these records in the first place. They've been photocopied from your service and they've then redacted them to give them back to you. That's not correct, and if you get into that difficulty, you should point that out to CQC. I would say it's worth a try. Don't make a request for the notes and then don't deal with your response because you expect to get them. Ask for them, get on with it as if you're not going to get them. And if you do get them, well, that's great. But it's not like it used to be and you'll get them as a matter of course. The factual accuracy guidance basically sets out the parameters of what you can challenge, and it's made it fundamentally clear that you can ask for changes in ratings and specifically good to outstanding. I'll take you to the paragraphs of that just in a second. Just one other practical point, again, which I would urge you to consider, is that there's some sort of delay between inspection reports getting published, then they go to some sort of centre where all the letters get sent out, and there's like a 3-day delay between the inspector doing the letter and the report going out, which usually means the cover letter gives the wrong date for submitting your factual accuracy comments. It usually cuts off 3 days. If you're going to do a challenge, it can be a big piece of work, especially if you're running a home on a day-to-day basis and you need to get evidence. Make sure CQC have got the right deadline. The guidance allows for you to have 10 clear working days. So if you've not been allowed that because there's been a delay getting it out, make sure you get enough time. This is just directly quoted from the guidance about what you can produce. What I think is important is in the last section, so the additional information, you can provide information that relates to the position at the home at the time of the inspection that addresses an issue that's not discussed in the draft report, but you think it should be included, or which you think has an impact on ratings. For example, exemplary practice to support a rating of outstanding rather than good. I have seen it recently where inspectors have come out and providers have tried to show them various pieces of documentation and they've said, I don't have time for that, or that's great, or for whatever reason they've not seen it, they've not looked at it. If you think that that's going to have a material impact on what should be in the report, and if it was available at the time of the inspection, you're more than within your rights to supply that to CQC and ask them to think about putting it in. And this is the type of thing that's key in good to outstanding. The reason I say that is another piece of information that's come out from CQC is that they're targeting their resources, as everyone is in this day and age, on risk and improvement. But there is a real tendency to now come in, do shorter inspections and produce shorter inspection reports. And sometimes things can get rushed through and things can get missed. But again, if they're not going to be out for 24 months, they've missed something that you were doing well, you want that in your report, send it across to them. What they've said is that they will review the factual accuracy responses before these go out to your service. Now, there's a legal case about this, which I'm not going to bore you with the detail, it's on the slides, but basically, very briefly, it used to be the case, you did your factual accuracy comments, you submitted them to CQC, the inspector, or the inspection manager, who's part of the team, essentially marked their own homework, and there was a tendency to be very, very defensive of inspectors and to not improve ratings. There was a GP practice, in this case, who challenged that through the judicial review process. They basically made detailed factual accuracy comments, supplied evidence that was available at the time of the inspection. The inspection manager just basically backed up the inspector and said, I'm not going to look at that, I'm not going to take it into account, not interested. That brings providers to the end of the road unless they want to consider judicial review, which is expensive and lengthy. And the judge said, and this is just key here, is that procedural fairness requires the CQC to have some sort of process to review its response to the factual corrections. Now, The way CQC have decided to do that is to say that they will be reviewed before they're issued to the provider, which I don't think is compliant with this test, but we're yet to see someone else take it to the High Court because it's very expensive, but it's worth bearing in mind. And what it does do, and it leads me on to my next topic very seamlessly, is that it essentially gives you another bite at the cherry before the ratings review process. If you get your factual accuracy comments back and you're not happy with them, then you can go back, you can quote that piece, because it's in the guidance, about it should be independently reviewed by someone else, and ask for someone independent at CQC to review it. Now, I've had some successes with that. I've had reports removed while they're being amended. I've had reports withdrawn. In other cases, CQC have point blank refused to deal with it. And again, it's like your inspection reports, it's variable from team to team, but it's worth thinking about as an opportunity, because actually after this stage, options for challenging your rating become more limited. And in the sort of last 5 minutes or so, I'll just quickly run you through the other options, but they are rating review, injunction and judicial review. I mean, these two are real remedies of last resort. They are available and people have done it, but I'm not going to dwell on that. Rating review, I'll just very briefly talk about. I've only got one slide because I've taken this from CQC's website, but it's up to date as at December 2017. And the point I want to make about this is that the grounds for requesting a rating review are so limited. It's only if CQC has failed to follow its published processes in aggregating a rating. They won't look at judgments and they won't look at evidence. So, I mean, there's almost no circumstances where these ratings reviews actually get through to the next stage. If you look, closed, no grounds, in adult social care, 353 out of a 478 total. I mean, not many of them get through. Another point to note, and it's the same with factual accuracy challenges, is that ratings can go up as well as down. So I always give that health warning. I probably should have given that at the start, but that's why your challenge has to be credible as well. We've had one successful, people tend not to instruct us for ratings review. We've had one successful one recently, and it follows on from what I said about being clued into CQC's guidance. Basically, a provider submitted factual accuracy comments and said they related to ratings. Must have been an old school inspector, came back and said you can't make ratings challenges through your factual accuracy process. And of course that's contrary to what CQC's guidance says. So that managed to get into the rating review criteria, and it was successful, but very limited. Factual accuracy challenge is your way to go if you want to get your rating from good to outstanding and you've got that evidence. Injunctions are basically, I mean, we all know from the media what an injunction is. Some providers have sought injunctions not to have their reports put in the public domain. It's a very, very high bar. You must remember that CQC has an obligation in the Act to publish reports. It's not a choice, they have to do it. And so even if there's a good case for it, it's not in every case that a judge would restrain publication. This is an Ofsted case where there was an injunction because the case was so riddled with error. I'll just leave you to look at that on the slides. Contrast that with the next slide, which didn't get an injunction. Just give you this headline warning. If you are thinking about it, you must think about the most compelling reasons and the risk of costs. Early this year, a provider sought an injunction against publication of reports they weren't happy with. Not only were they not successful, they also had to pay CQC's legal costs, which were in excess of £15,000. So take good advice if that's something you're thinking about. And judicial review is, well, that's the SSP case that I spoke about. That's how that got challenged, was through judicial review, because it was the provider saying, CQC haven't acted within the powers that they have. They're a public body, they should do that. I put this here not to give you a legal lecture about this, because this is a particularly dull section, but it's again to underline the importance of referring to CQC's guidance and keeping CQC accountable to what they've said in their guidance through your challenges and through the reports. Because ultimately, as a public body, if CQC don't behave the way they said they will behave, they are susceptible to judicial review. And sometimes all it takes is to remind them of that, not necessarily in an aggressive way, but in your challenge, you can say, you've said in the guidance, if we have evidence of outstanding, we can have that. And it sort of puts them on notice that you're thinking about the fact that if they don't comply with their guidance, then there's potential for challenge there. Other good bits of guidance to refer to in your challenges are the documents which I can send to you if you want, the FOI stuff that I've got, the inspection guidance, the report writing guidance, because they basically set out the framework for which CQC should inspect on. These are just slides about different types of judicial review cases, which I will leave you to read at your leisure if you wish. I won't bore you with that. I guess what I would say is the starting point is being prepared for your inspections, and you're all here, and that's and making the best use of it. Again, I don't dislike CQC. I think the best thing you can do as a registered manager, as a provider, is to build a strong relationship with your inspection team, and think of inspection as a collaborative process and not something that's done to you. At registered manager level, that's really good because you're aware of your responsibilities. You need to cascade that down to the staff members who may not have the same level of understanding of all the regulations, etc., but empower them, use the inspection as an opportunity for them to demonstrate what they're doing well. If for whatever reason, I can say this honestly, there are some really rubbish inspectors at CQC, There's some very good ones as well. If you find yourself in the situation where you're doing all you can and you get a report you're not happy with, this is when I would say the starting point for a challenge is a full and forensic factual accuracy response. It's the easiest win, essentially. It's where you can put all your information and evidence. So use the 10 days, supply evidence, set some time aside. It's not a straightforward job if you're going to do a good response. And it's where you can lay out the groundwork for saying, oh, you've not complied with your guidance, you've not met the regulations, you've not done this, you've not done that, so that if, God forbid, any further challenge is available, the groundwork is there. And if, for example, and I've not covered enforcement at all here today, but inspections also form the basis of the evidence base for enforcement action. And I should have covered that in the slides as to why you should challenge the report. But if you don't do anything about it till you get a warning notice, and then at that point you say, oh, actually that wasn't true, well, they'll say, why didn't you challenge it at the inspection? I could go on and on about CQC for ages, but I know you all look at me like, just be quiet, I want my lunch. So I am going to be quiet. I'm happy to take any questions if you want. I'm about for the next half hour or so in the lunch break. I can also give you my card if anyone wants to email me. But yeah, questions or I'll stop talking.
Could I just ask what you mean by statutory guidance?
Yes, so there's certain pieces of guidance that CQC are required to publish in terms of the Act. So the Act says you must produce guidance to give clarity on. So registering the right support is one example of that. It still makes it guidance, but providers have to have regard to it and they have to demonstrate that they've done that.
Is there potentially an offence if you fail to follow that guidance?
Not a criminal offence in that respect, but it can make things difficult. Where we've seen difficulties with it recently is people trying to register learning disability services, and CQC are saying you've not had regard to the statutory guidance, therefore you're not going to meet certain of the fundamental standards, and that comes up in notices of proposal. But ultimately, at the end of the day, guidance is guidance, and the regulator has to have some sort of discretion when they apply that.